case, Ms. Collins.
Good morning. My lady, my lords, I appear on behalf of the appellant, Christy Elan-Cane, together with Tom Mountford and Gayatri Sarathi, instructed by Naren Singh, Aralde Datri, Anne Collins and Jemima Rowe of Clifford Chance LLP. We are all acting for the appellant pro bono. Sir James EDQC and Sarah Hannett appear on behalf of the respondent, the Secretary of State for the Home Department, instructed by the Government Legal Department. Monica Cars-Frisk QC and Rachel Jones act on behalf of the intervener Human Rights Watch, instructed by McFarlane's LLP. They're also all acting pro bono.
I'm very grateful to all of you that are acting pro bono and all your teams as well. Before we start, could you please help us with this, Ms. Gallifant, as we're anxious to know by which pronoun the appellant wishes to be known during the course of this hearing.
The preferred pronoun of the appellant is per.
Is
per.
Thank you.
I may be referring to them as they or their, but per where appropriate, or alternatively appellant. But thank you very much indeed for checking that out at the beginning.
Not at all, and we will, of course, try our level best not to, when we're concentrating, to slip into any other pronoun that is not appropriate.
Yes,
I hope your lay client will forgive us in advance if we do that.
My lay client, I know, is very appreciative of the sensitivity that certainly the court below and this court intends to show to her them on that point. I'm very grateful.
Now, we have read all the documents that have been sent in. Obviously, we've read the judgment, we've read the skeleton arguments, we've read the supplementary review document. So I think you can take it that we're very familiar with the papers that we've had filed so far.
I'm very grateful for that indication. I've discussed timings provisionally with
Yes.
the parties. I would hope to finish in time for Ms. Cars-Frisk to have her 30 minutes today.
Yes.
But Mr. Eady understands that that may or may not be possible. We'll see how we go if we may.
I have to say, I think the three of us, in having a preliminary discussion this morning, felt that 2 days was a generous time estimate.
Well,
given the quantity of written material that we have.
I'm grateful for that indication. I'll certainly try to keep my submissions sufficiently crisp. But,
Well, I think we can rely on you for that.
I hope so. Just in terms of that then, and then obviously Sir James will be responding tomorrow, and then of course Sir James has his cross appeal.
Yes.
And just to indicate that Mr. Mountford will be dealing with the cross appeal in response.
That's very helpful, thank you.
My lady, my lords, will then be familiar with the grounds of appeal. In broad terms, there are 4 grounds of appeal. The first 2 relate to the human rights claims under Article 8 and Article 14, and the second 2 relate to the conventional public law challenge. My Lord, my lady, the challenge, of course, is to the lawfulness of the current policy of Her Majesty's Passport Office, which requires that an applicant for a passport must declare their gender/sex as either being male or female, accompanied by a declaration of truth. And a passport will only be issued with, in the sex box, M or F on the face of the passport. It will not be issued with the unspecified X gender marker, which is provided for by the International Civil Aviation Organization standards. The appellant's case is that that policy breaches their and other class rights under Article 8 and Article 8 with 14, and is in any event unlawful, and the court below erred in not so finding. The appellant identifies as neither male nor female, but as non-gendered. That is the most accurate and appropriate definition of PER's core identity. It is important to emphasise that the appellant does not herself identify as non-binary, which is the term used by the respondent, but the appellant does fall within the respondent's definition of that term, and therefore, for the purposes of this appeal, for the convenience of the court, I will tend to use the term non-binary when dealing with the respondent's submissions, but I hope the court will understand the importance for the appellant in it not being taken as a result that PER identifies herself as non-binary, but rather as non-gendered. That is a subcategory of non-binary. Now, the government fully recognises the existence of non-binary gender identity, and maybe I can take this quite quickly given the extent of pre-reading. The Government Equality Office analysis of the reform of the Gender Recognition Act consultation, and that for the court's notice it's supplementary bundle tab 7, page 0130.
Sorry,
0130.
Do you want us to turn it up?
Well, it might be worth just turning up because we'll come back to this bundle in a moment.
Sorry, my house seems to be about a mile away. Tab 7.
Oh, I'm so sorry, I'm giving you the wrong reference even there. It's 0123. I might, for the interest of time, skip the zeros at the beginning of the various
I think that would
ones.
be sensible.
At the top of the page, so this is the consultation analysis report. So there isn't a formal consultation document, but the respondents helpfully provided this. This is the analysis report commissioned by Nottingham Trent. And at the top of the page on 123, the government defines a non-binary person as someone who has a gender identity that is neither exclusively male nor female. Those with a non-binary gender identity may feel like they are, to some degree, both a man and a woman, that they are neither a man nor a woman, or that their gender identity is something altogether more fluid. The consultation used the term non-binary as an umbrella term to encompass a range of minority gender identities, such as gender fluid, agender, and gender queer. And our position is that the identity of the appellant of non-gendered falls within that umbrella term. The position in the consultation reflects the evidence to the court below in Miss O'Neill's witness statement, and I'll just give you the reference if I may, in the same bundle, supplementary bundle, tab 4A, at page 39, paragraph 6. One's gender identity is one's innate sense of gender, which could be male, female, both, neither, or fluid. Other descriptions of individuals who do not identify as either male or female include a gender variant. The category non-binary will also include persons who may be intersex, that is, having some physical characteristics of both the male and female sex. It will also potentially include some trans persons, including some trans persons during transition. It remains difficult to estimate with any precision the number of gender variant people, but based on studies and surveys available, it may be up to 1% of the population. So here in the United Kingdom, some 630,000 people. The government's own recent national LGBT+ survey received nearly 7,500 responses from people identifying as non-binary, so 7% of all respondents. The background to the challenge is set out quite fully in the High Court judgment. I would like just to emphasise a couple of the key facts. The appellant was born with female physical sexual characteristics and therefore registered as female at birth, but throughout Per's childhood, Per grew increasingly detached from the gender which had been assigned at birth. This has had a profound effect on Per's emotional and psychological development, to the extent that when the appellant decided to undergo 2 surgical procedures, the first in 1989, a bilateral mastectomy at the age of 31, and the second in 1991, a total hysterectomy at the age of 33. Now, the first of those was paid for privately, and the second, it may be worthy of note, was undertaken by the National Health Service. The appellant first contacted the UK Passport Authority asking whether it would be possible to issue Per with a passport that did not declare them to be either male or female nearly 25 years ago in 1995. The British Passport application form, a copy, I don't ask you to turn it up, is at tab 48 of the supplementary bundle, requires that gender must be declared as either male or female. In 2005, the claimant became aware of the availability of X passports, as I'm going to call them. Again, for the court's note, they derive from the Convention on International Civil Aviation, known as the Chicago Convention, which the court has in the Authority Bundle C, tab 55, and Article 37, which makes provision for customs and border control.
Sorry, article?
Article 37. And pursuant to that article, the Icao has obviously produced a number of documents setting out matters such as, in this case, machine-readable travel documents, which specifies, and that's again at tab 45 of the supplementary bundle, sex as a mandatory field on passports that can be machine-readable, and that can be completed with M, F, or X, and X is there described as unspecified. The appellant requested such a passport nearly a decade ago in 2010. That, the court's note, tab 10, pages 164 to 166. And at that point, the response from the Passport Office was effectively that the computer system wouldn't allow it. One could either input M or F, or nothing at all, in which case the passport couldn't be applied for. There was a series of further correspondence, which I don't need to trouble the court with, but in 2012 to 2013, the Passport Office carried out an internal review in relation to gender marking in passports. And I do ask the court please to turn this up. This is tab 16 of the supplementary bundle.
This is the internal review.
Internal review. The court will appreciate this is a fundamental document, we say. In large part, our public law grounds are based upon this document, but we do say that it is relevant for other purposes as well, and I hope just to identify the key parts of it. So, starting at page 176, at 177, the current policy is set out, which is, as I've described, which is either male or female must be selected on the application form. Paragraph 1.3, evidence of any change of name, for example, statutory declaration or vehicle, is also required. And the point there made is that the issue of a passport in the reassigned gender does not give any legal recognition to a change of gender. It states that there's no provision in the passport or the passport application form for a person to transition to one gender to no gender, or to state they do not identify in either gender. They say this is in line with UK legislation that recognises only the genders male and female. In passing, the court will have noted predates, so that's quite accurate. There are, in fact, pieces of Scottish legislation which are so recognised. That's at Authority Bundle C, tab 53. But the key elements here are the question of the options which are available. And turning on to page 180, paragraph 4.10, first of all, the internal review sets out legislative issues, pointing out that passports are issued at the discretion of the Home Secretary in exercise of royal prerogative, and there is no legislative requirement in domestic law setting out the gender requirement in the UK passport. However, it goes on, legislation in other areas recognises only the genders male and female. Therefore, what may appear to be a simple and inclusive change to passports could, I emphasise the word could, have wider reaching consequences. And some of those potential consequences are then set out in the other paragraphs in section 4. At the bottom, paragraph 4.7, if I may just highlight, HMPO could introduce recognition of a third gender, but it would be in isolation from the rest of government and society. There are likely to be so few applications for such a passport, but we would need to avoid issuing a document that was not recognised by other parts of government or wider UK society. Turning on to the next page then, section 5 sets out the options. There are two relevant options, I say. Option 1 was do nothing. That indicated that gender had been discussed and raised at the Icao Technical Advisory Group in December 2012, and Icao is adopting a similar approach to the UK, which is described as maintaining a watching brief on this area of work with regular updates and reviews, and I will, of course, come back to the question of such updates or reviews in due course. And option 5, on page 182, is the option of adding a third gender marker, X. And at paragraph 5.4, it's pointed out that that is already permitted by the Icao standards. But there are 8 bullet point concerns identified by the author of this internal review. Now, I'm going to come back to those particular concerns in due course when I come to the public law challenge. Further...
Ms. Cameron, do you mind if I just break in for a moment?
Yes, I'm so sorry.
Reading the scope and argument for the appellant, I was unclear whether your proposition is that it's a necessary implication of category X on the passport that there is a recognition of a third gender.
No, because category
Seems to me that
X...
the two sides seem to be passing each other.
We do, and we did below on that point as well. We say that X is unspecified. That is what is defined as the Icao standards. But we say that in order to pay the respect required under Article 8 and not to discriminate under Article 14, the issuance of a passport with X as unspecified is required to pay that respect, because albeit it does not identify the appellant as non-gendered, it does not require the appellant to make what the appellant would view as being a false declaration on an application form and to bear a passport thereafter with a false gender signifier, i.e. either M or F. So we say that the X marker is applicable to, in the future, all persons who fall into this non-binary category. It would be open to any member state of the ICO to make it available to more persons. So the question of the range of individuals to whom X might apply is ultimately a question for each particular state. And no doubt Sir James will say, well, some don't provide it at all, some provide it only for intersex people, and the like. We say that the Article 8 rights of the appellant in this case do require the issuance of an X passport in PER's case. But that is not the same as requiring the government to accept a third gender, as the government would put it, for all purposes. And that's the key point upon which Sir James and I miss each other and will continue throughout the next 2 days to miss each other.
Absolutely.
Fundamentally.
If it is purely a so to speak, an unspecified gender box, does it then follow, or would it be a possible response for the government to say that anyone, whatever their gender, could have the option of putting in an X just because they would rather not commit themselves one way or the other, or they don't want the authorities to know more than they have to about themselves?
That would be possible. In Malta, for example, one simply has the desire to be identified as X, and one can be identified as X. It's a self-declaration. In Australia, one makes the self-declaration, and then required in addition to that is a medical letter or a tick box exercise in Australia from a medical practitioner saying that the particular individual identifies as intersex or indeterminate sex. So it would be open to the government to have a very narrow category in relation to non-binary, or if it wanted to, it could make in the same way as making civil partnerships open to everyone, not just those who couldn't previously marry, but that's a matter for the government. But we don't need, as it were, to formulate the breadth any further than that. We say that on any view it would need to encompass persons in the position of the appellant, and no doubt other persons who fall into the portmanteau umbrella term of non-binary.
Thank you.
One more question. Sorry.
I'm sure it's not going to be the last.
No. I couldn't glean from the evidence that I've seen what the current position is for those who are intersex, in the strict sense, within our system for application of passport.
So, the passport position at the moment is that the birth certificate will be used as the primary document when making the application. So if your birth certificate identifies as you as M or F, whichever gender is assigned to you at birth, if you are intersex, then that is the sex marker which will be put onto your passport. If you are transgender, then you can change.
I understand that.
Exactly.
It's a simple question, a factual question. For someone born intersex,
Yes,
or is recognised as intersex, sometimes that can come later,
absolutely.
then the marker still has to be M or F.
That's right. There is no exception in the United Kingdom. No. Yes, and I'll certainly come on to...
You say the government could, it's a matter for the government, the government could use the third box as you would have it, in the same way it's used on a number of other documents where people can say prefer not to say.
Absolutely, and we've included in the bundle, I think, as an example from how one should create documentation that deals with gender or sex. It's actually, you might just turn it up, tab, maybe my lady's already seen it, tab 46 of the supplemental bundle, gender or sex. This is the service manual, and it gives an example on page 303 of an example of how to ask about gender. What is your gender? Female, male, unspecified. But of course, we entirely accept that in relation to passports, the government may wish to go down an Australian type route and say, well, if you're going to tick unspecified, we need a letter from a medical practitioner indicating that you do not identify as either male or female, or as are of indeterminate sex or are intersex. We don't have any difficulty with that as a principle. That's a matter for the government and implementation. But we do say that we are not exactly breaking new ground with the suggestion that there should be a third box called unspecified.
So for the government to say what the basis of acceptance of a claimed X
That's right.
would be, how that process would work.
That's right. So there are two stages. One is the government needs to offer it, and the second is the government needs to decide what criteria it will apply to when it will then be issued, the passport issued with X for unspecified. Yes, but we do say, on any view, However that policy is framed, it needs to include persons in the position of the appellant.
Yep.
The matters then moved on since the 2014 internal review to an extent in the key part, that there's further correspondence again, but the House of Commons Women Equalities Committee on Transgender Equality, published on the 8th of December 2015, that's at Supplementary Bundle tab 25, if I might just probably turn that up. I've just put in the recommendation section of that. Page 241. Just the final paragraphs that are highlighted at the bottom of 241. Paragraph 54. There is a need for greater awareness of trans people's legal right in most contexts to have their name and gender recorded as they wish without precondition. And this is the important part. It's commonly assumed there's such a thing in UK law as a legal name when there is not, and that legal gender must be proved in many situations when this is neither required nor appropriate. The government must take the lead by ensuring public services have clear and appropriate policies regarding the recording of individuals' names and genders. And then there's also a recommendation in relation to the medicalisation of the passport as an administrative matter, 241. Turning over the key point at 242, the UK must follow Australia's lead in introducing an option to record gender as X on a passport. If Australia is able to implement such a policy, there's no reason why the UK cannot do the same. In the longer term, consideration should be given to the removal of gender from passports. And can I just emphasise that there are two different questions at play. One is whether the Icao should simply remove gender as a marker, referred to as sex in the Icao documentation, whether it should go completely. So you no longer have M or F or X, you have no marker. The separate question, and the question with which this court is concerned, is whether you should have X available in this country as well as M and F. But as you'll see, there are a number of points in which we say that the government is simply asking itself the wrong question. It's asking whether the marker should be removed completely. That's a separate question. The question we say is, it's available now to have an X marker and that's what should go on. Whether a better route in the longer term is to remove it completely is a different question, not for today. We awaited the government response to that before issuing these proceedings. That's at tab 30. And simply to highlight at page 252, about halfway down the page, the paragraph starting currently. Currently, UK law only recognises male and female genders, and to introduce a third category donated by an X in the passport would require a change in primary legislation. Before such legislation could be introduced, we need to consider the impact that such a change would have on the personal safety and well-being of the individual, wider issues including public protection and combating identity theft and fraud. We would not see the passport as being used in the UK to recognise a third gender marking in isolation from other areas of government. I'll come back to this again. It is a slightly elliptical at best first sentence, because if one wasn't steeped in this, one would read the first sentence to indicate that in order to issue X in a passport, there is a change in primary legislation required. We say this is wrong. It's accepted in these proceedings that it's wrong, but we don't necessarily say it follows that the author of these documents understands that. And I'll come back to that in relation to the fourth ground. Of course, the claim was heard by Mr. Justice Jeremy Baker in April 2018, judgment handed down in June 2018, and permission granted by Lord Justice Bean in January, who noted the general importance of the issues raised. The Secretary of State's recently provided updates by two further witness statements, which go to the point of whether the policy has been kept under review. We've obviously handed up the note and sent it through yesterday in relation to that review, and I'll emphasise as I go through what we say has or hasn't happened since. Can I deal, unsurprisingly, in the following order? Article 8 first of all, Article 14, and then the public law grounds.
Just before you go on to that one, just dealing with the chronology of the...
Yes, of course.
You filed a chronology, for which thank you.
We did.
Core Bundle 99.
Yes.
Do you think I could prevail upon, or you could prevail upon, one of your juniors to cross-reference that chronology to the bundles? I see nods behind you. Thank you.
I think with enthusiasm. Yes, of course we'll do.
Well, they look keen at this stage.
We'll see as the day wears on.
Thank you very much indeed.
Yes, of course. Thank you.
Yes. is.
Now, we say the
Article
starting
8.
point, Article 8. Call us old-fashioned, we say the starting point for Article 8 is the question of whether it's engaged at all. Now, Sir James says no, we don't, in considering a positive obligation, need to consider engagement. He says that there's no support in the authorities for a separate consideration of whether Article 8 is engaged before you move to the question about whether a positive obligation arises. He says it's a duplicative exercise to do that. Now, we simply say that's not correct as a matter of fact, and I can take the court to any number of authorities where the Strasbourg jurisprudence says they do exactly that. If I can perhaps start with von Cook, which is in Authorities Bundle B, tab 33. Paragraph 69.
Did you say 69?
69. Tab 60, sorry. So it's tab 33,
Tab 33.
paragraph 69, page 1341 at the bottom. And you'll see the third line of paragraph 69, general principle, elements such as, for example, gender identification, name, sexual orientation, and sexual life fall within the personal sphere protected by Article 8. The same approach is adopted in the Scherner case at tab 31.
Just slow down.
I'm taking it pace because I hope this might not be controversial and one actually sees it happening time and time again, but I'm very...
But we just want to make a note of your
Exactly.
references, the order of them.
I'm very sure.
So we're
Exactly.
paragraph 69.
So paragraph 69 of Van
Which we've
Cook,
got, thank you.
that's tab 33, and then going back to tab 31, this is Scherner,
Yep.
and the relevant paragraph here is paragraph 37. This is on page 1292, using the bottom pagination. Applicability in Article 8 is the title.
Sorry,
So you have that. So it's tab 31, in
Yep.
the case of Scherner,
got it.
page 1294 at the bottom.
Ah, thank you.
Applicability of Article 8 at the very top is the subheading. And that paragraph concludes the subject matter of the complaint, thus falls within the ambit of Article 8. And then the court then goes on to consider compliance with Article 8, and that's where they then consider the question of whether or not a positive obligation arises. And just, I won't touch up at this point, the case of Hämäläinen, I'm very conscious that Ms. Cars-Frisk will be sitting in agony over my Finnish pronunciation, and no doubt will wish to correct it as she makes her own submissions, but at this point I'm going to, I'm afraid, mangle her native language. Hämäläinen, which is at Authorities B, tab 40, the relevant paragraphs are 57 to 61. Now, it isn't clear to us why the Secretary of State's taken this point, because, and I'll come on to identifying the same point in other authorities as we go, it might be thought that it's because the Secretary of State doesn't actually want to say in terms that non-binary persons simply have no rights under Article 8, and rather to say, well, actually no positive obligation arises. But it's quite clear that the starting point is, does the particular individual applicant have a right within Article 8, i.e. does it fall within the ambit of Article 8? And we of course say that it does. Now, when moving on then to the question of a positive obligation, the most recent formulation of the facts which should be considered when determining that issue are to be found in the case of Hämäläinen. If I might ask the court to turn that up, so that's at tab 40 in the same bundle. And this was a transgender woman who complained of a breach of her Article 8 and 14 rights on account of the Finnish Registry Office's refusal to change her identity number to indicate her female gender identity. And paragraphs 62 to 64 the court considered whether the case should be analysed as involving a positive obligation or an interference. And it makes the point 62, which is uncontroversial, that Article 8 may impose on a state certain positive obligations to ensure effective respect for the rights protected by Article 8. And paragraph 63, that will include the obligation to secure to their citizens the right of effective respect for their physical and psychological integrity. Going down to 64, the Court observed it was common ground there had been an interference, and the Chamber had examined it from that point of view, but the Grand Chamber in Hammerleinen thought that the question was whether respect for the applicant's private and family life entails a positive obligation on the state to provide an effective and accessible procedure allowing the applicant to have her new gender legally recognised while remaining married. The Grand Chamber therefore considers it more appropriate to analyse the applicant's complaint with regard to the positive aspect of Article 8. So they went down that route. But then when considering the general principles at paragraph 65, the principles applicable to assessing a state's positive and negative obligations under the Convention are similar, and I emphasise that. Regard must be had to the fair balance that has to be struck between the competing interests of the individual and of the community as the whole, the aims in the second paragraph of Article 8 being of a certain relevance. They point out that the notion of respect is not clear-cut, especially as far as positive obligations are concerned. Having regard to the diversity of the practices followed and the situations obtaining the contracting state, the notion's requirements will vary considerably from case to case, and this refers back to Goodwin, which of course I'll come on to. Nonetheless, certain factors have been considered relevant for the assessment of the content of those positive obligations on states. Some of them relate to the applicant. They concern the importance of the interest at stake and whether fundamental values or essential aspects of private life are an issue. And that's the first factor that I'll be taking into account. Or the impact of an applicant or a discordance between the social reality and the law. And here they make the point that it's the coherence of the administrative and legal practices within the domestic system being regarded as an important factor in the assessment carried out under Article 8. And I'll expand upon that if I may in a moment, because again, Sir James and I deal with the question of administrative coherence in rather different ways. Other factors, just above letter C, relate to the impact of the alleged positive obligation at stake on the state concerned. The question here is whether the alleged obligation is narrow and precise or broad and indeterminate, or about the extent of any burden the obligation would pose on the state. Paragraph 67. Now this starts in implementing their positive obligation under Article 8. In practical terms, it's not quite so straightforward always to see what's a question of implementation and what's a question of whether the positive obligation arises. But there is an important distinction, which I'll come to in Goodwin, which is when it comes to implementation, the state is generally accorded a wider margin of discretion, as distinct from the margin of discretion that may arise when considering whether or not the positive obligation arises in the first place. So at paragraph 67, there are other factors which must be taken into account when determining the breadth of the margin, and where a particularly important facet of an individual's existence or identity is at stake, the margin allowed to the state will be restricted. And that refers to X in the Netherlands and also Goodwin. Again, I'll come on to that. Where, however, and Sir James places a great deal of emphasis on the word however there is no consensus within the member states of the Council of Europe either as to the relative importance of the interest at stake or the best means of protecting it, particularly where the case raises sensitive moral or ethical issues. The margin will be wider. It goes on to point out there'll usually be a wide margin, this is the point that I make in relation to implementation as well, if the state is required to strike a balance between competing private and public interests or convention rights. And then at 68 it deals with the point in particular about the lack of legal recognition of gender reassignment surgery, and whilst affording a certain margin of appreciation to states, it is held, i.e. the Strasbourg Court, that in accordance with their positive obligation to recognise the change of gender undergone by post-operative transactions through inter alia, the possibility to amend the data relating to their civil status and ensuing consequences, and that's Goodwin, and then subsequently Grant.
It's going to prevent another interruption. I think this area is really very important for the case.
Yes.
If you don't mind, I'd quite like to slow it down a little bit.
Of course.
If the proposition on behalf of the appellant is that the state's obligations under to respond to her position under Article 8 involve a recognition of her non-gendered position, that's one thing. If, on the other hand, all that is involved is a bureaucratic change to deal with passports, and it is much less fundamental, then how does Hammerleinen, if that's how it's pronounced, help you in the way that you have assumed it right just by reading those passages. The first is clearly fundamental, and would be fundamental under Article 8. But if it's the second, that's fundamental.
Can I separate the question of civil status and passports? And I'm going to come on to deal with that at some greater length. As noted in the internal review, the issuance of a passport does not determine anything about the civil status of the individual concerned. It does not affect it. The reason in Goodwin why the applicant in that case went to Strasbourg was because Christine Goodwin wanted the change to her birth certificate. In other words, recognition for all purposes for her civil status. Now, it may be for another day that the appellant wants to make a wider argument, which is that actually PER's status should be recognised for all purposes, including civil status. But that isn't the challenge in these proceedings, because that is a narrow challenge to the issuance of a passport. Now, that's described by the learned judge below as being a forensic target. I believe that was Sir Reed James's word. But the reason that we say that that challenge should succeed is precisely because the passport does not affect civil status. So I leave for another day the wider question of whether the gender identity of persons such as the appellant, non-gendered individuals, should result in a change to the birth certificate and a third category on the birth certificate, because I don't make that argument today. But I do make the argument, which is that in order to give adequate respect to PER's rights under Article 8 and not to discriminate against PER under Article 14, it is necessary for the state to provide for the very simple administrative option of an X on a passport.
It's the engagement of Article 8 and the degree of its engagement that I was putting to. Fundamental identity questions must engage Article 8.
We absolutely agree.
And that's what Hannah Lehn's establishing sets out.
Absolutely.
When we're dealing only with the question, I call it bureaucratic. I don't need to downplay it. But it's of much less fundamental importance. That's the way you're putting it.
Well, can I be clear? When I don't accept this as of much less fundamental importance. The change on a birth certificate, and I'll come on to this if I may in relation to trans persons. The change on the birth certificate affects the change for all civil status purposes. So, prisons, education, health, social care, all of those things. The passport does not of itself do that. But I do not say that the passport is therefore somehow insignificant for a person such as the appellant. On the contrary, the appellant's evidence, and my lord has the second witness statement of the appellant's evidence as to the extremely problematic feelings that PER has, firstly, when having to make the application on what PER regards as a fundamentally false basis. So PER has an option. They tick M or F, so PER would tick F, and that is a false declaration that PER makes in order to obtain a passport. So that is the choice. PER can either decline to have a passport and not be free to travel outside this country, or PER must tick F. Once PER receives the passport, then that passport in this country, in the absence of an identity card system, that passport is generally recognised as the most convenient way of proving one's identity.
Well, one knows if an application is made, for example, for a driving licence, it immediately filters through to the passport.
Yes. And equally, one goes to, even in this country, one might be asked to see a passport when opening a bank account, going to a
All the money laundering regulations.
Yeah.
Money laundering regulations, exactly. So it's used for those purposes. It's not a document that simply sits in a drawer as a birth certificate would, but the birth certificate, of course, defines you for all civil purposes. So in terms of day-to-day life, I'm not suggesting PER uses her passport every time PER goes to the shops, but every time PER will be asked to prove PER's identity, it is likely to be the document that is the starting point for that proof.
I suspect quite a good test for many people is simply how easily they can lay hands on their passport. And most of us have to do that frequently and therefore can, whereas
Yes.
digging up one's birth certificate involves a great upheaval, and usually I've forgotten where it is, and it takes a long time to find it, which just shows it's something you need once a decade, probably.
Exactly, and that exactly. So we don't accept that, as it were, the passport is somehow of so little significance that Article 8 isn't engaged. On the contrary, we as I hope to develop, we absolutely submit that the provisions of Article 8 entirely apply to the fundamental right to identity, gender identity, including the appellant's gender identity. And we say then the interference, when one comes to consider the extent of the interference with that right, what Strasbourg refers to sometimes the inconvenience, but that's a rather modest word, we say, for the actual impact and suffering of a person such as her. That needs to be gauged against the particular way in which the individual seeks that right to be respected. Now, in this case, that is the passport. As I hope I'll explain, the reason the passport matters so much is not just travel, it's also because of its use at a domestic level. So I wouldn't accept that, as it were, the passport is merely a nice thing to have, an accoutrement, but not fundamental to one's existence.
So by that route, you say Hamalainen does apply.
Absolutely.
With some force.
Yes.
Although we're not talking about fundamental identity, we're talking about day-to-day life.
Well, I'm talking about fundamental identity for the purpose of day-to-day life. But what Hamalainen would do, and of course everyone is asking for something different in all of these cases. So in Goodwin they're asking for change to the birth certificate. Other individuals are asking for, in some of the later cases, that, for example, domestic law in other states, which required sterilisation before you could transition to the alternative sex. Those sorts of provisions. In each case there are different aspects of personal identity that's under consideration. The aspect we challenge is in relation to passports alone. But let me make it clear, we don't say that that means that Hamalainen doesn't apply. Hamalainen does apply because I'm relying, of course, on a positive obligation. But I will, if I may, anticipate, when I come to the public law grounds, we say that on any view, this policy is irrational because we simply say, in that context, one has to look at what justification is offered for it, and we say those justifications, for the same reasons that they fail in relation to Article 8 and Article 14, they fail simply as a public law position in any event. So my law puts to me, as it were, it's simply a diminutive thing, putting an X in a box rather than an MRF. We agree to that extent when it comes to the, as it were, the classic public law challenge that I'll come on to.
So just hooking that in, if I may, for a moment, into the judgment, which after all is the
Yes.
subject of the appeal.
Yes.
Mr. Justice Jeremy Baker, you would say, got the emphasis wrong in relation to his assessment of the importance of birth certificate versus passport.
Very much so.
Paragraph 114, perhaps, in his judgment?
Yes, I've got a notion it's slightly further on, yeah, but we'd entirely agree that
I'm just trying to factor in what
Absolutely.
your submission is to the judgment that
appeal.
we have to, yes, because it is an appeal.
no, I understand that entirely. That's exactly right. Because although one can say, and no doubt Sir James will say, well, the birth certificate changes your civil status, we say that one can't then extrapolate from that actually the passport is effectively insignificant, it's no more than a bus pass.
No.
That's simply the wrong approach. So yes, we say he profoundly underestimated the impact of applying for and using a passport.
Thank you.
Can I then just start with the factors concerning the individual? My Lord, Justice Irwin has already highlighted. The question is whether the interest at stake is important and whether fundamental values or essential aspects of private life are an issue. We agree entirely that's a relevant factor to take into account. And we also note, of course, that gender identity is one of the most intimate private life matters. And we see that from Van Cook. That's, if I might.
But is that an issue? Is there an issue between the parties on that proposition?
Yes, it is. Yes, it is, because the Secretary of State's position is that gender identity is one of the most intimate private life matters, where that identity is male or female.
Sorry, say that again.
Gender identity is accepted by the Secretary of State to be one of the most intimate private life matters, and therefore falling within the potential for being a positive obligation under Article 8, where that identity is either male or female. So the Secretary of State's position, as we've always understood it, is that where one does not identify as male or female exclusively, simply no rights arise under Article 8. and I go back to the
So
point
no rights for non-binary.
no rights for non-binary and no rights for intersex to the extent that the signifier on their birth certificate may not accord with the exclusive male or female.
It seems to me a powerfully counterintuitive conclusion that Article 8 has nothing to do with something as fundamental as one's gender, if one's gender is anything non-binary.
We respectfully agree, and we refer back to the learned judge on giving permission in the first place.
Yes.
And he put it in this way. He said, well, if you are going to, as it were, respect the rights of a person who identifies as male, a person who identifies as female, and a person who transitions from male to female or female to male, what if effectively they stop in the middle, that they're in the middle? And we respectfully agree and reiterate that our position is as straightforward as that,
Well,
which is...
Sorry.
I'm so sorry.
No,
It is
go on.
whether one stops in the middle in terms of transitioning or whether one simply is in the middle in terms of gender identity, we cannot see any basis for limiting the scope of Article 8, whether it's in the context of a positive obligation or otherwise, to exclude those who do not identify exclusively as male or female.
Well, particularly when the medical definition of gender dysmorphia includes non-binary.
We find it very surprising that in these proceedings, and even more so as matters have developed since the High Court, that where you have the National Health Service, and my lady no doubt is referring to the document at the back of the supplementary bundle, the National Health Service defining gender dysphoria, we have the evidence of Ms O'Neill from the Government Equality Office, again, setting out what gender identity means, which includes those who identify neither as male nor female. And then the consultation on the Gender Recognition Act and the definition of non-binary individuals. We find it very, very surprising indeed that the government maintains its position that no rights arise in relation to those who identify as non-binary, i.e. not exclusively male or female.
Would you give me a moment?
Yes, of course.
That's the government. I mean, they will deal with that, no doubt. Is that remain the position of the government?
My lady, the position of the government is slightly more nuanced than that, but I don't
Well,
want
I'd
to
rather
get
thought it might
I
be,
don't
but
want to get
in
into-
principle.
I don't want to get into that debate now, if I
Fine.
may.
All right, thank you very much. Well, perhaps we can move on because we're very clear about what your argument is on that.
I mean, I do have a number of authorities
Yes,
that I
well,
would take the court to, but whether you wish me to do that now or perhaps in reply, depending on what Mr. Reader says, is I'm entirely in your hands.
Why don't we see what happens?
Let's proceed on that basis in that case. I'm grateful. The other point that's made is in connection with the question about whether a non-binary identity, such as non-gendered, actually falls within Article 8 at all, is that the inconveniences are not sufficient in the case of the appellant, such as to engage Article 8. So even if PER's gender identity were in principle within Article 8, there's a separate question, which is the extent of that discordance between social reality and the law. And, my lord, I read the section of Hammerleinen which refers to this in the terms of discordance between social reality and the law and coherence of administrative and legal practices within the domestic system. And I want to separate out those two issues because they don't necessarily run together. Discordance, it's clear, and this is what I was referring to, discordance is typically dealt with in Strasbourg by way of reference to inconveniences. In other words, it's what is the impact on the individual. So if I may take, my lady, my lords, to the case of B in France, which is in Authorities Bundle B, tab 30. And B in France is a slightly different case to the British position because, as you see, this was a transsexual born male but following gender reassignment surgery lives as a woman, and the French government refused to allow her to change her civil status. If I could ask the court just to pick up that paragraph 63, page 1243. and this is of course the point that I'll return to and I've already highlighted in relation to the position in the United Kingdom, but in France the position was rather different. Because in France, and this was of course, B was trying to distinguish Rees, saying, well, the court should
Internal
follow.
page number?
Sorry, 1248 at the bottom. Paragraph 63.
Thank you.
So France, just as the United Kingdom, didn't have any specific legislation which allowed for the change of the gender on a birth certificate. But what B had argued, 63, is the situation in France is not comparable with that of the United Kingdom, where, as the court found in Rees, and I will come back to that, transsexuals, like anyone else, are free to change their first names and surnames at will. And so moving to paragraph 69, B, all the documents produced by her and official papers such as passport, identity card, voter's card, driving licence are established under the name of Mr. M.B. and various administrative documents concerning her. And also her incident number was allocated with one, a code for the male gender which appeared in her social security card. And this is the Commission's conclusion that the applicant indisputably suffers particularly trying ordeals in daily life because of the discrepancy between her appearance and entries concerning both gender and forename on the documents relating to her, whether official or not, and more particular identity papers. Discrepancy forced her to reveal to third persons details of her private life, whether performing everyday functions, travelling, having even minor treatment, finding work, etc. The judgment of the court starts at page 1254. And they don't deal with the documentation point in quite the same way. They deal at page 1259. Setting out again at paragraph 59. An increasing number of official documents indicated sex, extracts of birth certificates, computerised identity card, European Communities passports, and I'll come back to the shift as a result of European Communities passports in a moment. But the position of the applicant in B was that effectively the words, the documents that she used in her daily life, all referred to her as he. And the government, the French government, replied to a number of documents that didn't mention sex at paragraph 61 and effectively said there was really no reason why it should be verified and effectively there was no need to trouble herself. And the court at 62 was not convinced by this argument. It considers, in agreement with the Commission, which is why I took my lady and my lords back to the Commission's view, the inconveniences complained of by the applicant in this field reach a sufficient degree of seriousness to be taken into account for the purposes of Article 8. And the conclusion, just going over then at paragraph 63, is that they reached the conclusion which distinguished the case from Rees and Cossey, those are the two United Kingdom cases. She finds herself clearly in a situation which, taken as a whole, is not compatible with the respect due to her private life. And we say that the position for the appellant, so far as the passport is concerned, is no different. And my lord, my lady, that may recall that the appellant, for example, took quite some time to persuade RBS, as I set out in her second witness statement, to remove the need for a gender marker when applying for an online bank account. So there are a number of aspects of ordinary life that the appellant battles with in terms of removing and not having to identify as either M or F when those sorts of things arise. We accept, of course, that it's slightly different to France in the sense that there are no identity cards and the like, but we say the stress and the alienation that the appellant feels is no different to that of the applicant in B. Just a reference also then to Goodwin itself at paragraph 77. I might turn up 77 in Goodwin, because this was the case, the seminal case in which the Strasbourg court found that there was a positive obligation in relation to the civic status of trans persons.
Sorry, Ms. Cameron, you lost me.
I'm so sorry.
Goodwin is
Tab 32.
tab
Sorry,
32.
I was, as it were, forgetting completely to tell you the key part of the information there. Tab 32, para 77. And this is, it must be recognised that serious interference with private life can arise where the state of domestic law conflicts with important aspects of personal identity. The stress and alienation arising from a discordance between the position in society assumed by post-operative transsexual and the status imposed by law which refuses to recognise the change of gender cannot be regarded as a minor inconvenience arising from a formality. A conflict between social reality and law arises which places the transsexual in an anomalous position. He or she may experience feelings of vulnerability, humiliation and anxiety. We say that is exactly the same here. Separate to that consideration, paragraph 78 is the question considered in the court's case in Goodwin of coherence of administrative and legal practices, because what they point out by and are struck by is the fact that the gender reassignment had been carried out by the National Health Service, which recognises the condition of gender dysphoria and provides inter alia reassignment by surgery. And the court was struck by the fact that this is provided, which might be regarded, they say, as the final culminating step in a long, difficult process, and the coherence of administrative and legal practices within the domestic system may be regarded as an important factor. Where a state has authorised treatment and surgery alleviating the condition of a transsexual, alleviating the condition of a transsexual, financed or assisted in financing the operations, and indeed permits artificial insemination of a woman living with failed male transsexual, it appears illogical to refuse to recognise the legal implications of the result to which the treatment leads. And we say that that is referring to an existing incoherence. That's paragraph 78, and I'll come back to this in relation to the question of justification. And a separate one. We say it's hard to overstate the degrading effect of having to declare your gender, which is such a deeply intimate and fundamental characteristic, to be something that it is not. And we respectfully agree that the downplaying, as it were, of the relevance of the passports was an error by the learned judge below. The respondent, in skeleton paragraph 12, suggests that the appellant suffers some prejudice. In other words, appellants' feelings in having to identify themselves in official documentation as a sex or gender that does not reflect their identity as non-gendered. But they say that that stops short of the consequences identified by Christine Goodwin in this case. We say again that completely understates and doesn't reflect the impact of the passport policy on the appellant and others in the affected class who do not identify as exclusively male or female. We note also the significance of that mismatch referred to in Kate O'Neill's second statement. I don't ask my Lord to turn it up. Supplementary Bundle 6A, paragraph 11, at page 72 to 73. So in the recent survey, a number of comments linked to the belief that gender-neutral identifiers would greatly increase non-binary people's quality of life because having to identify as a specific gender can be dysphoric and damaging. And that's referred to in that statement. Again, if I may just give the court the reference, the mismatch was recognised in L in Lithuania, that's at tab 35 of the authorities, paragraphs 57 to 59. In that case, a fair balance was found not to have been struck, noting the distressing uncertainty vis-à-vis his private life and the recognition of his true identity. We say all of this is exactly the same here. The respondent also suggests that the appellant doesn't identify any disadvantage in terms of victimisation and harassment based on the F marking in their passport. I've given in our skeleton the reference from Transgender Europe and the International Lesbian, Gay, Bisexual, Trans and Intersex Association, which states that in terms, that's Supplementary Bundle, tab 3A, page 20 at paragraph 15, and that's a point that Ms. Cosfrisk will be picking up in due course.
Right, paragraph
15, 1-5. On coherence, I'm sure the court will already have anticipated, the principle is exactly the same for the appellant as it was in Goodwin, because the NHS has paid for one of the appellant's surgeries for gender dysphoria. That is exactly the same position as in Goodwin, only in the appellant's case, that surgery was in order to align PER's physical characteristics with PER's gender identity, that is, non-gendered.
Once you develop that principle, don't you lead yourself into the position that the government is saying, which is, all right, there may be a historic incoherence because the state has paid for an operation, but if once you change the passport, then in isolation from all the other things which need to be considered together, they would say, that disrupts the process and minimises coherence of law and that you're better, therefore, to pursue a thoroughgoing review of the whole area and come to the conclusion that's general.
We respectfully wouldn't agree. For the reason,
Well, you might not,
for the reason, which is in relation to trans persons and Goodwin. Because just stepping back for a moment to the position of the appellant, the next factor to be considered is the factors that concern the state and its systems. So there is one aspect of administrative coherence, which is if it's incoherent, that's a reason for saying the positive obligation arises to correct that incoherence. That's the Goodwin position. The Secretary of State's position is a different position, which is, well, actually, we shouldn't be looking at this in isolation, passports in isolation, we should be looking at things in the round. Now, on that, we say that the impact of a positive obligation on the state is very simple. It's simply one of cost. Now, that cost is estimated at £2 million. We make the unsurprising point when the government is spending 450 million on blue covers for passports. That really seems a very small amount indeed. But we don't understand the financial burden to be the burden particularly relied upon in isolation, were it just to be passports that needed to be changed. But the reason why we say the government's position is effectively illogical is because passports can and do stand separately to other administrative and legal practices. And if I may go back to the decision in Rees, tab 29 in bundle B and C. It's in part B of this bundle. So this is the decision in 1986, Greece and the United Kingdom. So it's some 16 years before Goodwin. And the position in 1986 here is that the applicant is a person who was identified as female at birth and transitioned to become male and wanting the correction of the birth certificate, just the same as later Christine Goodwin. And at paragraph 17, page 1224, in terms of the facts, paragraph 17, the applicant considers himself a man and is socially accepted as such, except for the birth certificate. All official documents today refer to him by his new name and the prefix Mr, where such prefix is used. The prefix was added to his name in his passport in 1984. B, section B under domestic law and practice identifies changes of name, and it's common ground that under English law a person is entitled to adopt such first names or surnames he wishes and to use them without restrictions or formalities, except in certain circumstances. And persons very frequently make a deed poll, a declaration in that form, which can be enrolled for that purpose. And the second part of paragraph 19, new names are valid for purposes of legal identification, may be used in documents such as passports, driving licence, car registration books, national insurance cards, medical cards, tax coding and social security papers, and the new names are also entered on the electoral roll. And then we come on to identity documents at paragraph 20. Civil status certificates or equivalent current identity documents are not in use or required in the United Kingdom. Where some form of identification is needed, this is normally met by the production of a driving licence or a passport. These and other identity documents may, according to the prevailing practice, be issued in the adopted names of the person in question with a minimum of formality. In the case of transsexuals, the documents also have to be issued so to be all respects consistent with the new identity. Thus, the practice is to allow the transsexual to have a current photograph in his or her passport and the prefix Mr, Mrs, Ms or Miss as appropriate before his or her adopted names. And turning on, if I may, to paragraph 25. This deals with the status of the birth certificate. The law does not require the birth certificate to be produced for any particular purpose. It may in practice be requested by certain institutions and employers. In particular, a birth certificate has in general to accompany a first application for a passport, although not for its renewal or replacement. Now, in Rees, the court found that there was no positive obligation. And at page 1228, paragraph 42, pointed out that it says, with delay and some misgivings on the part of the authorities, the United Kingdom has endeavoured to meet the applicant's demands to the fullest extent that its system allowed. The alleged lack of respect comes down to a refusal to establish a type of documentation showing and constituting proof of current civil status, and that's the point that I made earlier. The introduction of such a system has not hitherto been considered necessary in the United Kingdom. It would have important administrative consequences and would impose new duties on the rest of the population. It finds that the governing authorities of the United Kingdom are fully entitled in the exercise of the margin of appreciation to take account of the requirements and determining what measures to adopt, while the requirement of striking a fair balance may possibly, in the interest of persons in the applicant's situation, call for incidental adjustments to the existing system, it cannot give rise to any direct obligation on the United Kingdom to alter the very basis thereof. And pausing there, just in terms of my Lord Justice Irwin's query, that anticipates a position whereby you might say, well, actually, the positive obligation doesn't extend to altering a birth certificate, but it does give rise to, for example, incidental adjustments to an existing system. So we say that that is entirely consistent with the Strasbourg reasoning, that we look for an adjustment in relation to a passport, but not the entire system. And Goodwin itself, just going back, if I may, to tab 32, at page 1307, at the very bottom of 1307, relevant domestic law and practice, A, names. The top of 1308, under English law, a person is entitled to adopt such first names or surnames he or she wishes. Such names are valid for the purposes of identification and may be used in passports, driving licence, medical insurance cards, etc. The new names are also mentioned in the electoral law. So the same position as it was in Rees. Now, the reason that clearly historically and currently, we say, persons are allowed to change their names in this way, and then they're rolled out into other such identifying documents, is because the issue of passport in a reassigned name and a reassigned gender, such as in the case of Rees and Christine Goodwin, does not give rise to any legal recognition of a change of gender, and that we have already seen, having been pointed out in the internal review published in 2014 at paragraph 1.3. So prior to Goodwin, there was apparently no difficulty with an individual in the position of Rees having a situation where the person's passport was issued, for example, as male, and for all other civil status purposes, they were female, in the absence of an amendment to the birth certificate, which wasn't, of course, at that time possible. It has never been suggested that that situation caused any difficulties or that the administrative incoherence was in any way relevant. Now, of course, in response to Goodwin, the government did introduce a system for the change of the birth certificate, and that's via the Gender Recognition Act. We don't actually have that act in the bundles, but if the court would like a convenient summary of it, that's most readily found in the decision of JK. That's Authorities Bundle A, A1, I think it is, tab 11, at 610, paragraph 5 onwards. The key point to note in relation to...
Do you want us to turn that up?
Not unless, I'm happy to, as it were, leave it for further reading, but just to note the key point in relation to the Gender Recognition Act then, is that one makes an application to a gender recognition panel, one pays a fee, currently £140, one has to put in evidentiary requirements, which include 2 medical reports, one from a registered medical practitioner or psychologist in the field of gender dysphoria, one from another medical practitioner, who must indicate that the individual has or had gender dysphoria, has lived in the acquired gender for 2 years, intends to live in that until death, and complies with other evidentiary requirements. So that is the Gender Recognition Act. It's common ground, it doesn't apply to a person of non-binary status. But the Gender Recognition Act then is aimed to remedy the problem identified in Goodwin, that is the inability of an individual to change the birth certificate. So for all civil purposes, that they were treated as male when they were now female, or vice versa. The results of the most recent LGBT plus survey indicate, and this is, if I may ask you to turn it up, Supplementary Bundle 7B 0116. Is the report on the national survey, the summary report from July 2018, so after the High Court. It starts at page 94, but the passage that I would just like to take my lord and my lady to, page 116, in relation to other headline findings.
116.
Yeah, 116. So it's the very big 23, but the littler 116.
Can you do an internal page number as well?
Yeah, big 23.
Tab 7.
Tab 7.
7B.
And 7B. So this is the exhibit to the statement of Mr. Entwistle. This is one of the updating statements from the Secretary of State, which we're very grateful for. So 7B, internal pagination, very large, number 23, much smaller number, 116, the bundle pagination. And it's the page that starts other headline findings. And under Gender Recognition Act, it points out that the 2004 Act allowed trans people to apply for a certificate to bring in line the gender marker on a birth certificate with other documentation and to be legally treated in the gender in which they identify. Again, the Act does not cover non-binary gender identities. Of the trans men and trans women respondents, 12% who started or finished transitioning said they had a gender recognition certificate. Only 7% of those who were aware of the certificates did not have and had never applied for one and said they would not be interested in getting one. Reasons for not making an application were satisfying the requirements, 44%, process being too bureaucratic, 38%, or expensive, 34%. Respondents could accept more than one reason. So based on that, 88% of trans men and women don't have a gender recognition certificate. So they are in the same situation as they would have been pre-Goodwin. Unless they have changed the gender recognition certificate, their birth certificate will still identify them in the sex of their birth, not the acquired sex and gender. But they are, however, fully able to change their passport. And that, if I might ask the court to turn on tab 44 in the same bundle. This is page 296, tab 44 in the supplementary bundle. This is additional information for transgender and transsexual customers issued by the Passport Office. And 298, under the section, you have a valid British passport from your birth gender but wish to apply for a new and acquired gender. It sets out, just below the first hole punch, what needs to be provided as part of that application. You will need to include one of the following: a birth or adoption certificate in your acquired gender, or a gender recognition certificate, or a letter from your doctor or medical consultant confirming that your change of gender is likely to be permanent, and evidence of your change of name, such as a deed poll. So the requirements are, as it were, with the minimum formality. There's simply a letter from doctor or medical consultant confirming the change of gender is likely to be permanent, and then you also need to identify change and evidence of your change of name. So trans persons can obtain a passport, just as Rees did, and no doubt Christian Goodwin had, in their acquired identity, with the minimum of formality. But 88% of them don't have a gender recognition certificate, based on the survey. So those people are in exactly the same position as pre-Goodwin. For their purposes, there is a fundamental disconnect between the documents such as passports where it's an acquired gender that's identified, and the birth certificate, where it is a birth gender. And there is nothing inherent in an X marker, non-specific, that makes the potential difference in terms of administrative coherence any different. Paragraph 15 of the respondent's skeleton, it said, and this is why the Secretary of State says we can't go down this route of having passports dealt with in isolation, it would lead to the same person being treated as having a different sex stroke gender by HMPO for the purposes of issuing a passport on the one hand, and by all other government departments for all other governmental functions on the other. Well, that is precisely the position pre-Goodwin, and it is precisely, in principle, the same position that 88% of trans people find themselves in today, 15 years on after the Gender Recognition Act. So simply, instead of having a situation whereby the difference is that the incongruence between two different binary identities, M and F, the discordance is between having X and having M or F. So we say it's against that background where the current position, in practical terms, is no different to the position pre-Goodwin. And that the vast majority of trans people are already in the position that the Secretary of State is so worried about arising were the Secretary of State to enable persons such as the appellant to identify as X on a passport. We say it's against that background that you have to consider these arguments on administrative coherence. And we say there must be a healthy scepticism applied to those arguments, where apparently, and there's no evidence before this court, there was none before Mr. Justice Jeremy Baker, that this situation, so far as trans persons are concerned, has created any difficulties or issues. Can I move then to the jurisprudential basis that's advanced by the Secretary of State for the administrative coherence aim? Now, for this purpose, the Secretary of State relies upon the triumvirate of cases from Strasbourg of Rees, Goodwin and Hämäläinen. I've already indicated in relation to Rees, the point there that was made was in relation to the fundamental effect that the change of the birth certificate would have in terms of civil status. And there would have to be detailed legislation, they said, on the effects of the change in various contexts and the circumstances in which it should yield to secrecy. And, well, I took you to... Sorry, I've just got a tumble exploded. In relation to Rees, let's go back to the later tab 29 on C. Paragraph 44. Page 1229 made the point that in order to overcome the difficulties, this was the difficulty about maintaining secrecy in some circumstances and changing the birth certificate in others. I'm so sorry, I know that I'm cantering, I will try to slow. Tab 29, page 1229, para 44. So in order to overcome the difficulties, this was in relation to the modifications that would be required, and of course in that situation what the applicant was asking for was an annotation in the birth certificate, but the change be kept secret from third parties because the birth certificate register is publicly accessible. And then they refer to the difficulties that would arise as a result. So that's exactly the sort of consequential impact that we say wouldn't apply here, because we're simply changing the passport to allow for X. The other case relied upon for this administrative coherence as a legitimate aim is, of course, Goodwin. That's at tab 32. Paragraphs 86 to 88 on page 1321. And and that deals with, under the heading, impact on the birth register system, that what will be required in terms of the integrity of the birth certificate, the birth register certificate, in the event of a change such as that sought by the applicant. And can I just, while we're on Goodwin at paragraph 87, just ask the court to note that in Goodwin at that time, it was estimated that the category of transsexuals included between 2,000 and 5,000 persons. That was the United Kingdom estimate at that time. I'll come back to that in due course. It also refers to detriment suffered by third parties unable to obtain access to original entries and the like. Hammerlinen, which is the third authority relied upon by the Secretary of State on this administrative coherence point, Hammerlinen is at tab 40 in the same bundle, and my lords, my ladies, we've already been to this. This is paragraph 66. This was the key paragraph setting out the general principles to be applied. Well, all Hammerlinen does at paragraph 66 is just refer back to Goodwin. And we've seen what Goodwin says, it's referring to the integrity of the birth register certificate. And it's against that background that the respondent relies upon the need, as they put it, for an administrative coherent system for the recognition of gender. As I've already explained, that need has never been felt to be quite so pressing, as it were, for the last 40 or so years when it came to passports, as it apparently is in the last couple of years.
But you do accept it as a relevant consideration. I think you do. You do accept it's relevant, but you say it should be given very little weight in these particular circumstances because experience has shown it doesn't really cause problems in practice in this type of field.
I accept it's relevant to consider the issue, and the issue is what's the burden and the impact on the state. I absolutely accept that that's relevant, and that's why my starting point is, in terms of passports, the impact is a top estimate of £2 million to change the system. The Secretary of State's position is, well, no, the burden is far greater because of all the other matters which could be required to be looked at. In other words, the Secretary of State's position is, well, actually, we don't want to look at passports in isolation. We want to look at everything in the round.
Yeah.
And my position is, well, so James can say that, but that has to be tested against the reality of there being no coherent system at the moment as between passports for persons who don't have a birth certificate reissued, who've transitioned in their acquired gender, but who may well have a passport issued in their acquired gender. And that discord has never troubled the Secretary of State over 40 or so years. So my point is it's not so much the weight to be given to it, it's actually that suggesting that there is some importance to this aim is rather undermined by the current position that pertains and has pertained for 40 years. So one has to view those arguments on administrative coherence with something of a raised eyebrow, would be my position.
Well, it may be we need to be suitably sceptical about assurances of that type, but if it is within the range of relevant considerations, and if there is a fairly wide margin of appreciation in this area, then the conclusion might be, and I suspect this is where the judge ended up, that this is at least a legitimate way for the government to decide to proceed.
Well, we'd say that the legitimacy is obviously dependent upon the balance. And what needs to be weighed in the balance is the factors applicable to the applicant and the factors applicable to the state, and then some of the other matters that I'll come on to. We simply don't accept that the factor of administrative coherence weighs anything like in the balance. And perhaps, my lord, as we're coming back to where you started, giving it little weight, perhaps that's the right way to put it. It's simply that what they say in terms of the need for administrative coherence, we say, is undermined by the current practice. And therefore that, as it were, gives it little weight. Now, there's a difference, isn't there, between what the government says they would like to do to achieve an administrative coherent scheme and whether actually, when considering where the fair balance is to be struck, so what is actually being asked for by the applicant, taking into account the impact on the applicant, and what the burden on the state would actually be, and we say that burden is limited to changes to the passport application process and issuance X rather than M or F, which we say is extremely narrow. In considering that, we say the balance falls very squarely in our favour, and that's why when one looks at the question of administrative coherence, the desire on the part of the government can't be the test. It may want to look at things in the round, but the question comes down to, at the moment, is there a fair balance struck in terms of the positive obligation that we say arising? And we say no, there isn't. And of course, it's highly relevant to take into account the existing state of affairs in that context.
Isn't it implicit in the whole thrust of your argument that there won't be a fair balance struck even if the passport changes because of the other things that remain unaddressed?
There will be a fair balance in the context of passports and that its use as an identity document. There will, of course, be other elements of civil life in which a fair balance has not been struck. I absolutely accept that. But that, we say, is no reason at all not to strike the right balance in this particular area. And that's, we say, exactly what Rees effectively said one could do. If one was looking at the narrow and limited obligation that's being identified, that could be appropriate, as it were, amendments to the existing scheme. We say this is effectively an amendment to an existing scheme, rather than the wholesale change based on the recognition of a third gender, if you want to put it like that, a gender that is not M or F, a gender category, that is, of course, what the Secretary of State says at the moment they want to do. That may be right or may be wrong, but that can't, we say, actually stop this court considering the more nuanced question of the limited applicability of the positive obligation in relation to the passport.
So I think on your argument, it would make all the difference if the third box, if the relevant regulations said it had to be filled in with a T for third gender rather than with a totally non-committal X.
Well, at the moment, it can only be filled in with an X because that's what the Icao standards provide.
Yes, I know. But I mean, supposing the whatever they're called, Icao regulations said you had to put in something more positive, like a T as the third gender, or figure 3. I mean, then the argument that you can't ring-fence passports would be that much more powerful, wouldn't it?
It may be. I'm not sure I would quite accept it in that way, because even a T would have no effect on your passport, would have no effect on your civil status. So I'd say whether you put X, T, Z, whatever in that box, it just means not male or female.
Well, I'm not sure about that. I mean, you're rather pinning quite a lot, I think, on the proposition that the X is totally non-committal. It doesn't carry any baggage with it. But I wonder how realistic that really is.
Well, we do say it's realistic because the whole point is that the reason that passports stand by themselves is that they don't have a knock-on effect for civil rights, as in you know, education, social services, whichever things like that. Now that is going to be the same whether it says T, Z or X, and that's the point that I'm making. I understand my law's point, which is, well, T would by implication suggest that this was referring to a third gender rather than a person who, for example, in Malta could simply say, I don't want to say that I'm male or female, I just want to say X.
Yeah.
So that person would no longer be able to apply for that passport. But that presupposes a world in which the ICAO standards say something different. So my position is we have to look at the position as it currently stands.
Yes.
I take my lordship's point, but that isn't the current position. And perhaps the direction of travel, as you may have gleaned from the papers, is actually to remove the gender identifier altogether.
I quite see the direction of travel may well be gathering momentum, and in due course it may lead to changes across the board. But of course that's not what you're asking for.
No, but I'm just making in terms of direction of just from the ICAO, just in terms of the question about what goes in the box, X is unspecified. Well, that is the position currently. That has been the position for decades,
Yes.
that X is for unspecified. In the absence of a change to that, it would be X for unspecified, because that's the mandatory requirement for the machine-readable passports. My lord's point is, what if the government, as it were, did something different and said, well, it should contain T rather than X for third gender? Well, I still wouldn't accept that that meant that the government had to recognise T in other areas as a consequence of changing the passport.
No, but I think possibly what Lord Justice Henderson was concerned about as well is what impact that would have on their argument for coherence, because they would say, right, once you get T, that's a third gender, and then the government absolutely is driven to having to look at everything else.
Well,
Because that is in one discrete area, albeit under the Crown prerogative, albeit in passports, where there appears to be in this jurisdiction a recognition of a third gender. So I think what was being said is surely that would massively increase the argument. Is that right?
Yes, absolutely. Thank you for putting it better than I did.
Well, it would become a conflict. Because that would be a recognition of the third gender when the primary law doesn't. It confines gender to two genders.
Well, but we've mentioned the Scottish position, at least in some part, there is a recognition of a third gender. So this is not new ground. It may be slightly bigger ground than in terms of football violence in Scotland, but which is the context in which the third gender is identified in terms of those sorts of offences. But the point
I
that
think I'm just really trying to sort of calibrate the strength of argument, the coherence argument of various different possibilities.
yes, and I understand entirely.
You know, so I can put your argument into the...
At the top, please, my lady.
Funny you should say that.
No, what we do say is, even if you put a T in the box, we don't accept that it would necessarily follow that the government would then have to think about how you recognise a third gender if you describe it in that way, which wouldn't be the way that the appellant would describe it, because there is not one third gender. This category of non-binary contains a multitude of gender identities. So we suspect that, and the government's position is not that there should be a third gender. It's effectively there's this category of non-binary persons, which include individuals such as the appellant. So we don't think this is a likely scenario, but even if the government, having persuaded the ICO to change its position on whether it means X for unspecified or X for something else that contains a T, even if the government went down that route, we still wouldn't say it would follow that there would be these second order consequences. Because what you see in Rees and Goodwin is they are consequences that must happen, because if you change the birth certificate, there is a necessary knock-on effect for civil status. If you change the X to a T, there is no necessary knock-on effect.
Thank you.
If I may then also deal with the case of SV in Italy, that's in tab 45 of Bundle B. This is relied upon by the Secretary of State, again, in terms of saying about the impact on the state. This is a case in which the applicant had asked for a change for her forename to correspond to her gender. Sorry, his gender. Sorry, yes, no, her gender. In terms of by the prefect. So she had asked for an administrative decision on the question of the change of name, and the position of the Italian courts, one sees at paragraph 17 at page 1728, was that the amendment of civil status documents had to be ordered by the court ruling on his or her gender reassignment. And we say this case is helpful for us because, firstly, at page 1736, the court first of all assessed the applicability of Article 8 of the Convention. So that's the starting point, the question about engagement at all. It then went on to consider compliance from paragraph 60 onwards. And at paragraph 62, it referred to the balancing of competing interests, the particular importance of the matter relating to the most intimate part of an individual's life, namely the right to gender identity, and pointed out that that's a sphere in which the contracting states have a narrow margin of appreciation, seeing Hammerlein and AP Gus and Icao, and I'll come on to that case in a moment. But this is a case relied upon by the Secretary of State in terms of administrative coherence. The administrative coherence issue in this case was entirely different, because here, and going on to paragraph 69, the question was the choice of the Italian state and the legislature to entrust decisions on changes to civil status register concerning transgender persons to the judicial rather than the administrative authority. So that's the administrative coherence point, in SB in Italy. It doesn't just...
Give me a moment, 369, would you?
I'm so sorry. And just in passing 72, I simply point out that this is an applicant who is having to wait for an unreasonable length of time for the anomalous position to be remedied. They refer to the experiences of vulnerability, humiliation, anxiety in Christine Goodwin. So we say again, the respondent's arguments based on there being, as it were, less impact on this appellant, we say simply don't reflect the approach of the Strasbourg court. Can I turn to the domestic authorities on this point? There are two relied upon by the Secretary of State. They're both in Authority Bundle A. I'm sorry, the first is in Authority Bundle A1, and that's the case of JK and the Registrar General. And that's at tab 11. And what is said here by the Secretary of State is that this case stands for the proposition that effectively there's a legitimate aim in an administrative coherence scheme for the recognition of gender. Just to be clear, in JK, what is said here, and you can see the argument, I might pick it up from paragraph 98, which is on page 622. The legitimate aim that was relied upon by the Secretary of State was having an administrative coherence system for the registration of births. So it was a somewhat more limited scheme, and this was in relation to the question of the birth certificate of the child biologically fathered by the person who had changed gender to female. So it was all concerned with the registration of births. And similarly, and I don't ask the court to turn it up, but in TT and the Registrar General, a very recent decision of the family courts, Authorities Bundle A225, again, the submission in that case, that's at paragraph 244, was that there should be a consistent, clear and certain registration scheme for the registration of births. So we say neither of those cases assist the respondent in showing that there's this overarching scheme in terms of gender. And of course, what we say on that goes back to my point in relation to current position and pre-Goodwin for trans, which is there currently is no such coherent scheme. So it is slightly invidious to try and insist upon the importance of that coherent scheme when it comes to non-binary persons, but not when it comes to trans persons.
So the proposition is, despite these authorities, there actually is no coherence. We could have that. Why does that bite on the... Why does that not illustrate the capacity of government within the margin of appreciation to say we want to be sure of achieving maximum coherence rather than operating piecemeal?
Well, because the position is that the appellant's rights are, we say, being breached today.
We understand.
And we say that...
So would other people's rights if incoherence is accentuated or expanded.
Well, we wouldn't accept
Why
that.
is it not within the margin of appreciation to address the thing?
Well, my lord, I did an absolutely critical point, which is no one else's rights would be impacted by allowing one individual to put, or 20,000 to put X in the passport. Because unlike the cases of JK and TT, where the rights are balanced against the rights in particular of the child born to the individual who may have changed gender, that right exercise that's carried out obviously creates the wider margin of discretion because there are different sets of rights in the balance. And that's set out in Hämäläinen at paragraph 67. So where there are rights of others that go against the balance of the particular applicant, the individual seeking recognition of their rights, I absolutely accept that gives right to a wider margin of appreciation. What I don't with respect accept is that in this case there is an impact on the rights of others were the appellant to be able to put X in the box when applying for a passport and carry a passport that identifies per as X, unspecified. So I don't accept that as a point of principle. because I simply say that you have to consider whether fair balance is being struck. So it's not simply saying, is it acceptable for the government to think, well, actually, we'd like to do more for persons in the non-binary category? Well, I'm sure no one would be more delighted than the appellant to learn that the government wants to do more for persons in that umbrella category, of which per would fall within. But that's not the point. The question is whether that balance is a fair balance vis-a-vis this particular applicant and the burden on the state. And we say there you have to look at what the burden on the state actually is, not what, in theory, in many years' time perhaps, the government may decide the burden should be to introduce a non-binary category as a matter of civil status. So, aspirational, we don't have any difficulty with it, but we do have a difficulty with the idea that that aspiration should prevent there being a fair balance at the moment. Now, before the High Court, the respondent argued that there was a need to legislate and change policy in other areas of government function. For your reference, that was paragraph 51 of their skeleton, core bundle, tab 11, page 200.
Sorry.
Sorry.
Again. Okay.
I'll
First
come back to
instant.
trot rather than a canter.
Yes.
So,
Sitting trot, please, as well.
I will try.
Right.
The
So,
High Court-
skeleton argument.
Skeleton argument, respondent. That's at core bundle, tab 11, page 200. And there, the respondent had argued that there was a need to legislate and change policy in other areas of government function were they to accede to the appellant's request to have an X in passport. Now, that is no longer, as far as we understand it, from the Secretary of State skeleton, no longer the position. Instead, what is said is that it doesn't follow there is a need. It's not a necessary consequence. It's identified as being problematic and undesirable. And that's paragraph 15 of the skeleton before this court. Or that a decision on the recognition of non-binary people cannot sensibly be made in isolation from other areas in which sex and gender is irrelevant. Now we say they are, of course, right to abandon the argument that there is a need to legislate. There is neither a need to legislate to change the passports, nor is there a need to legislate in other areas. But their desire to do so, as now expressed in their skeleton at paragraph 15, cannot be an answer to whether that is a legitimate aim which weighs so firmly against the interests of the appellant that the fair balance is struck. And we say that, contrary to the respondent's submission, that's paragraph 17 of the skeleton, this position is not analogous to that considered by the House of Lords in Bellinger and Bellinger, because, of course, that case concerned civil status directly, and passports do not affect civil status. So there are no necessary consequences that flow from permitting people to apply from and issuing an ex-passport. So we do say that the arguments on administrative coherence are themselves incoherent, and that's our position on that primary aim that's identified by the Secretary of State. And I spent some time on that because it is clear that the other two, the question of security, are somewhat make-weight. You'll see the length they're given in the skeleton of the respondent, but I'll deal with it if I may quite quickly. These are the other two factors in terms of impact on the state. So when you're carrying out the the exercise, the Hammerlein exercise, what are the relevant factors, and then how do you balance them? Security is identified in two aspects. One is essentially identity theft and fraud, giving rise to security issues. The other is security at borders. The evidence as to security, in the sense of fraud and identity theft, we simply highlight the importance of exercising caution, that it's not used as a pretext for discrimination. Paragraph 49 of our skeleton, we've cited the the United States case of Schroer and Billington, which emphasised the need. It was a security guard whose security pass couldn't be reissued, and a acquired name of ensuring that security isn't used as a pretext for what is effectively discrimination. But the evidence relied upon by the respondent is set out in the witness statement of Mr. Woodhouse. That's in the supplementary bundle, tab 5A, and this was one of the witness statements that was a piece below, for Jeremy Baker. And that is at paragraphs 27 to 33. And one sees there the starting point: sex is relevant when issuing passports because it's a recommended requirement for MRPs by Icao, and by abiding by such recommendations we ensure the UK passport is accepted around the world. So that goes back to, as you said, the Icao documentation in relation to the mechanically read passport requirements, which require sex as a marker. But that doesn't tell you anything about X as a marker, because of course Icao enables X to be provided. So this section starts with the wrong issue. This considers the issue of security if you remove the sex marker completely. And that, of course, was what had been considered in 2012, was then considered again in 2016, potentially. The deliberations on whether you actually just strip it away completely. So here, Mr. Woodhouse's evidence is based on sex being relevant, but that, of course, proceeds on the basis that already you have a system whereby you have internationally M and F and X. And so that's why we say that Mr. Woodhouse's evidence on security doesn't bear the weight suggested, because you already have a system where you have X. What Mr. Woodhouse is in reality talking about is, what if you had no sex marker at all? And that isn't what we're suggesting. And as I said, just in terms of the ICAO's views on it, just for your note, it's paragraph 20, Mr. Woodhouse refers to that having been considered by the ICAO completely. But it's clear that he's going down the wrong approach. Should you remove sex completely is not the question. Should you allow X, which the ICAO already does, that is the question. Now, the suggestion that's made by Mr. Woodhouse is that if a person applies for a passport, if the gender on the application form doesn't match the gender on the applicant, it could indicate, the application form, it could indicate potential fraud. So if you put in a birth certificate which says M and you apply for the passport with F, he says that could indicate potential fraud. Now the starting point, as my Lord will readily recognise, is that's the position for the vast majority of trans people. Always has been, still continues to be, until there's a change in the Gender Recognition Act, which means that more people take up that certificate. But in any event, it's possible to do it, because it's possible to put an X on your application form. So you apply and say, I want a passport in the name of X, and you produce your birth certificate. Now your birth certificate will say M or F. So there is already that mismatch. Internationally, that will always be the case, unless you have a country where birth certificates can have an X on them. And in that respect, we say that there really is no security risk greater as a result of having X than there is as a result of the current situation with trans people, where there is a mismatch between M and F, whichever way around it might be. So the security arguments, so far as identity theft are concerned, we say really don't take matters any further at all. Firstly, they're directed at the wrong target, removal of the sex marker. And secondly, it's difficult to see how that can be a good argument, considering the extent to which the position already exists in relation to trans people and internationally. Now, the respondent seeks to rely on the case of C and the Secretary of State for Work and Pensions. It might be, just given the time, I just highlight this. This is in Authorities Bundle A2, tab 15, the legitimacy of the aim of security in the sense of fraud in respect of recording transgender identities. That was a case in which the individual challenged the retention on a DWP system of the information that she had had a different sex, and it was considered that the retention and recording of that information was being considered. And simply in that context, we note that Lady Hale pointed out in paragraph 35, the real issue is not the aim, but the balance between the ends and means, which is the essence of the proportionality calculation. It's fair to say in that case, the Supreme Court didn't find that there was disproportionality. They found that the aim was justified and the proportionality was adequate. But that's a very different situation to the current. We don't dispute that the legitimate aim in most contexts would be trying to prevent identity fraud, but one cannot identify it as a specific aim, we say, against the background where you have trans people and international situations with X passports already being issued. And that then goes on to the question about border security. The suggestion that, for example, the border staff at home and abroad must check the sex to detect fraud, we say again, this is fundamentally flawed. It genuinely does fail to take into account the existence of ex-passports. And it's never been disputed by the Secretary of State that persons travelling from countries where ex-passports are issued to the United Kingdom have no difficulty coming through the borders of the United Kingdom and leaving again. The systems work because they're machine-readable passports in accordance with the Icao standards, and there have been no issues identified by the respondent, security issues or others, of the use of ex-passports in gaining entry and exit from this country. Now, in this context, the respondent relies upon the views of other ICO members, in relation to the review that was carried out or initiated, and I'll come back to this in the final grounds, by HNPO in 2017. And if I can deal with it quite quickly, Mr. Woodhouse indicated that essentially they'd sent a survey out to a number of member states in January 2017. They'd received some answers, and then they'd sent out another questionnaire in October 2017, so the same month as permission was granted in these proceedings. As at the date of Mr. Woodhouse's statement, which is the 18th, if I recall correctly, the 18th of October, what Mr. Woodhouse says about that is that there have been 20 responses to that questionnaire. And just go back to, we're in the bundle at same tab 5. You see, I'm just picking it up from paragraph 21 of Mr. Woodhouse's evidence. So the questionnaire is sent out on the 9th of October, following up from a previous survey. As at the 9th of October, we see the questionnaire goes out, and at paragraph 23, Mr. Woodhouse says they've had 20 responses from 20 countries, and responses were still coming in. Should they be of sufficient quantity, we'll consider whether a report needs to be issued. Now, what Mr. Woodhouse provides is a copy of a draft document, which is at tab 5B, which is called Review of the Use of Sex Markings in Travel Documents. This is entirely concerned with removing sex/gender markings, and we see that page 70E, the title 5. And so all of the considerations and conclusions are dealing with that different question of whether you should strip out the sex marker completely. None of it is dealing with ex-passports. And in particular at 70G, under conclusion, the second paragraph on page 70G says, on the whole, this review has found the removal of sex-gender markings was not supported by the majority of the responding countries. Well, that doesn't tell you anything about the views of those countries in relation to the use of ex-passports. And we say it is notable that, and we'll come on to it, that what happened was, having realised that they really didn't have, as it were, what they needed in relation to ex-passports, they then send out a further questionnaire, and that questionnaire is a very specific questionnaire. It's at page 70, as it were, a big fat 0 at the end. So 70, just at the back of tab 5B. It only asks about ex-passports. It doesn't ask about other things about sex markers generally. It only asks about ex-passports. So that's the document that's then sent a couple of days before our permission hearing. Responses are received. We don't know what those responses say. We've never seen those responses. So we don't have the information before this. It wasn't before Mr. Justice Jeremy Baker. It's not before this court, obviously, as to what they say. But that's the relevant information, that's for collation, because that's where you'd understand whether there are any security concerns in relation to ex-passports, not the review that is in draft anyway, because it's where they didn't have the stuff that they needed in relation to ex-passports. So reliance on that, we say, is equally misplaced. And can I just make the point further, that the reason for conducting the survey was that the United Kingdom offered to do it as part of the working group, or working party, I think it's called, the advisory party for the ICAO. So the government said back in 2016 that they would conduct a survey on sex and X markers in passports. They didn't even start that survey until January 2017. They have never finished that survey, because we know now from the updating statements that all work on this stopped after Mr Woodhouse's statement was put in October 2017. So 2 years later, clearly the government hasn't considered what might have been said about ex-passports, and perhaps more importantly, neither has the ICAO as far as we're aware, because we can't find any reference anywhere to there being further consideration of an issue that the government volunteered to look into back in 2016, some nearly 4 years ago now. So we think that's relevant when it comes to the question of review, because effectively the government doesn't have the information, or hasn't certainly provided it so far as the responses as at October were concerned, that may provide any insight into what countries actually think about security when it comes to ex-passports, rather than the more general question of removing the sex marker completely.
Factual basis of what you just said is page 155, isn't it?
That's right, I'm sorry, I preceded it rather.
Farmer that statement, paragraph 5.
Exactly, so that's Farmerlow saying,
Page 155. 8.
yes, so Farmerlow says nothing has happened since, and the reference in Mr Woodhouse's statement for him, agreeing the UK agreeing to commission the questionnaire is paragraph 14 of Mr Woodhouse at page 59. So we say there simply isn't any credible evidence, or wasn't before the court, and certainly none's been admitted now, in relation to any security issue at borders in respect of ex-passports. And we'd be very surprised, of course, if international standards which provide for them had allowed something to happen which had any significant negative impact on security. They've, of course, been issued by various countries and used in order to access this country. So we say that equally that is a very underwhelming in terms of weight aim to weigh against the interests of the applicant. I'm going to move, if I may, then to consensus, which is the third factor that's relied upon by the Secretary of State before coming to that balancing exercise. And the respondent suggests that uniformity of views or practice in other member states of the Council of Europe and international trend will be a factor in determining whether a positive obligation arises. Now, we agree that it is a factor. We do not agree it is a key factor, as it is described. It is one of the factors that was identified in Goodwin. The others were, as we've already identified, the applicant situation, impact on the birth register system, which I've taken you to both of those, and the other one was medical and scientific considerations. We don't say there are any different medical and scientific considerations. The position is simple. So far as gender dysphoria is concerned, and the non-binary category, it's recognised by the NHS and it's recognised by the government. There's no need, as it were, to go further than that. We say there is a clear and uncontested evidence of continuing international trend in favour of the issuance of ex-passports for non-binary persons, and we've set out in our skeleton, core bundle 3, page 28, at the footnote, to paragraph 1, so internal page 28, sorry, bundle page 28. The countries that allow for unspecified gender passports and the year in which they allowed for them. And you'll see that at least 2 of those member states, Austria and Germany, allow for them after the date of the decision below. So the trend, we say, continues, has continued since the decision below. And internationally, since the decision below, Uruguay has also joined that group of countries. We do note that the resolution of the Council of Europe's Parliamentary Assembly, we say, is relevant. I won't ask the court to turn that up. That's at that's at Supplementary Bundle, tab 3B, page 30. That calls on member states to consider including a third gender option in identity documents for those who seek it. Just to anticipate a point that's taken against us, which is that an international trend can't include a resolution by the Parliamentary Assembly of the Council of Europe. Again, just the reference, if I may give it, in YY, Authority Bundle B, tab 41, paragraph 110, makes it clear that certainly Strasbourg takes those into account when considering international trends. We also note the Select Committee report, the Women and Equalities Select Committee report, as an international trend. Now, it's suggested that we breach Article 9 by doing so. We don't see we breach Article 9 of the Bill of Rights in any way. We're simply referring to the fact that the committee has made that. We're not impeaching it or criticising it. We're simply suggesting that they have made the recommendation that this country should follow Australia's lead, indeed must follow it, and we rely, of course, on the Secretary of State's response to it when it comes to the grounds that we say that the policy is itself unlawful as a matter of ordinary public law grounds. So we don't accept that we are trespassing impermissibly on the parliamentary privilege. We do also rely upon other contracting states which allow birth certificates to record indeterminate sex. Now, some care has to be exercised here because the respondent says, well, we're falling into a trap of identifying a trend in relation to intersex only and not in relation to persons of indeterminate sex, i.e. not born intersex, but who do not identify as exclusively male or female, such as the appellant as a non-gendered individual. We don't accept that's an accurate summary of the position, and if I might just deal with two of the cases. I hope that my Lord already has an Authoritative International. It doesn't have a letter, as it were, it's just an international bundle. Start, if we may, with the decision of the German Constitutional Court, tab 2 of that bundle. And just looking first of all at the head note, the position was that the general right of personality protects gender identity, and it also protects the gender identity of those who cannot be assigned either the gender male or female permanently. And the basic law also protects persons who do not permanently identify as male or female against discrimination based on gender. And both of those rights are violated if civil status law requires the gender be registered but does not allow for a further positive entry of a male or female. So this is a case that goes further than we seek in these proceedings. This goes to the registration, the equivalent of the birth certificate in terms of registration and gender on the birth certificate equivalent. And you see at page 17, using bundle numbers, it's 4 out of 15 internally, and this is a translation. The original, for those who prefer to read it in the original, is a tab B of this internal tab B of this tab. You'll see that the constitutional complaint under reasons A is that it concerns the complainant who is assigned female gender and registered as a girl in the birth register, but who have an atypical set of chromosomes, so-called Turner syndrome, permanently identify with neither the female nor the male gender. And the situation under German law is that a child, this is just the next part of A, a child has to be registered either as female or male, and if this isn't possible, then no gender entry is made, so that blank is left. And we say that the reasoning that leads to the head note, the reasoning encompasses not just intersex persons, but other persons who identify as in this case, non-gendered.
Sorry, can you just say that a little more slowly? You
Yes.
say the reasoning.
The reasoning, absolutely, encompasses. So the facts are, exactly, this particular individual was intersex, but we say that you cannot simply start by saying, well, this is an individual who was intersex, and therefore the reasoning of the court is in relation to intersex, because it isn't, it's wider than that. And what happens is that paragraph 3, although I think the paragraphs are somewhat difficult to follow, if one looks at page 20, I'm going to use the bundle numbering. Under heading 2, you'll see that there had been a German Medical Association opinion submitted, and just, if I may pick it up from the first hole punch, deviations in gender development include congenital variations in genetic, hormonal, gonadal and genital dispositions of a person due to a person's gender, does not unambiguously correspond to the biological categories of male or female. And they then go on to guidelines by the Urology German Society, just below the second hole punch. How people handle deviating gender development is in principle a socio-political issue and must be considered in the context of society as a whole. and they make it clear that gender cannot be determined, let alone created, by genetic, anatomical or chromosomal features alone. It's dependent on social and psychological factors. I can deal briefly with section B, which deals with the general right of personnel to protect and contain its gender identity. They said the assignment of gender is of paramount importance for the individual identity. And just at the bottom of page 22, using the numbers in the right hand, it's the paragraph with 42 to the right hand of it. It notes that the complainant, whose gender deviates from male or female gender development and who permanently identifies with neither the male nor the female gender, she is denied a gender entry which corresponds to their gender identity, because the only option is missing. And they then go on to point out that, on the next page, the individual does not identify as genderless, but as a gender beyond male or female. And the court finds at page 24 that the interference was not justified, and they say it's an unconstitutional legal provision compelling a person to have a gender entry under civil law status whilst denying them a further positive entry other than female or male is not based on a legitimate aim for which the provision would be suitable, necessary and appropriate. They also find that the costs associated with that do not justify the option, or refusing the option of a further gender entry. That's on page 25 by the number 52 on the right hand side. And then getting down to page, not quite para, but as it were line number 52, although they're paragraphs numbered differently to the actual paragraph numbers. On 25, just above the second hole punch, allowing a positive entry for a third gender with a standardised third designation does not result in any assignment difficulties that do not already exist under current law. Uncertainties may occur where a provision outside of civil status law is linked to gender and presumes a person is either female or male. In that case, it would be indeed unclear how a person assigned to the third gender should be treated. However, the same issue exists already under current law if the gender entry is left blank. So I say that's a very similar analysis to the analysis that I say applies in relation to trans persons in the United Kingdom. And finally, in relation to discrimination on page 26, just below the second hole punch, again using the numbering on the right hand side of 59, persons who identify as neither female nor male are particularly vulnerable in society, primarily organised according to binary gender patterns. And they then say a particular thing about the wording of the basic law about gender. But in short, we do say that the question about whether this is limited to those with intersex characteristics is answered by the analysis that's undertaken by the Constitutional Court, i.e. that there is no difference between individuals who do not permanently identify as male or female, so far as the protection of their identity is concerned, because they are intersex or because they are not. And we say it's wrong to suggest that there's a different policy imperative when it comes to those individuals. The policy imperative is the same, as is made clear by this case. It's about gender identity, which, as is emphasised, is not simply a medical question. Indeed, it is not a medical question. And that's the point that I raised in relation to it depending on social and psychological factors. So we say, in all cases where there is a gender identity, which is not or not exclusively female or male, that may well be the same for intersex people. They may identify as either male or female, or neither, as in the case of the applicant in this case. The same reasoning we say applies in the Zegers case from the Netherlands, tab 6 in the same bundle. This is a recent decision of a district court in the Netherlands of May 2018. Actually, it's easier to follow because the paragraph numbers are slightly more consistent. Page 354, so the interested party was born as an intersexual, as it's translated. And considerations since the law, you see at 357, so the situation there is that since 1999 in the Netherlands, you could draw up a birth certificate.
Gallifrey, could you just slow down just a little?
Yes, I'm so sorry.
You're going very, very fast. Page 357, and where are you reading from?
Sorry, 356. So just above the second hole, sorry, above the first hole punch, paragraph 2.2.
Yeah,
And it's a similar sort of provision to that we saw in German situation. If it couldn't be M or F, there's a provision here, but a more recent one here, about drawing up a birth certificate stating that the gender of the child could not be determined in the event the gender of the child is doubtful. But that article didn't apply because it didn't have retroactive effect, and I think this individual was born in, 1961. And the Supreme Court then examined, in a case of March 2007, whether there should be recognition for an application that the birth certificate was wrong, even when it didn't, when there was not a mistake. It was really that there was a change. And the decision in 2007, and this is the Supreme Court's decision, which is in italics at the top of page 357, which concludes that about 6 lines from the bottom, it said, in this decision it's taken into account that from appellant's case documents, obviously not this case, the Supreme Court case, it's shown there is gradually more attention to intersexuality, especially in cases where a person has sexual characteristics of both genders, and different problems in relation to that, but not that there is a trend towards judicial recognition of a neutral gender in cases where a person is convinced to, regardless of their physical appearance, neither belong to male nor female gender. So that's the position in 2007. In other words, there may be an international trend in relation to intersex, but there is not a national trend, they say, in relation to recognition of a neutral gender, i.e. not male or female. But what the court says in 2018, paragraph 2.5 is, as will be shown below, the court considers that in the 11 years since then... 2.5, so halfway down page 357. In the 11 years since then, this is 2018, there has been social recognition and also at least a trend towards legal recognition of a neutral gender identity as described below, and they refer to a third gender. And then they deal with social developments, in particular in relation to Dutch society, as well as international legal developments. I'm going to leave Ms. Kars-Frist to develop matters in relation to, in particular, the Yogyakarta principles that are dealt with on pages 358 and 359. But in relation to developments in Europe, they point out the endorsement of the Yogyakarta principles and the resolution that I've referred to, Resolution 2048, which we say it is permissible to take into account when considering a legal trend. And it notes that there is a growing body of case law that allows for recognition in the case of YY in Turkey. I'll come on to that also. And then the Garçon and Nico in France judgment, just at the bottom of page 359, the European Court ruled that the right to private life entails self-determination with regard to sexual identity. So the developments internationally, and then they also, for completeness, note at 360, Christine Goodwin's case. The conclusion of the court is page 361, just above the first hole punch, under paragraph 2.6, conclusion. It says, all things considered, the court considers the following. The court is of the opinion the interested party has made it sufficiently plausible that her gender is ambivalent. She has also sufficiently demonstrated that she is convinced that she is neither male nor female. The district court does not consider it necessary to carry out further investigation to determine which form of intersexuality is involved, because the medical determination of a form of intersex condition stroke DSD, that's divergent sexual development, does not yet establish how the person concerned experiences his or her gender. As considered above, this person can feel completely male or female or neither. It is therefore important when determining the gender to look at the gender experience of a person instead of the physical appearance or medical condition. And they point out that that's in accordance with a previous law in which the requirement of physical adaptation for transgenders has been abolished. And just the final paragraph on this page, the court is of the opinion that the gender experience is of decisive importance, and they conclude that it should be possible to record the experience of being neither male nor female as such in the instrument of the civil registry. By, for example, mentioning an X, it's not yet possible to do so. And then they go on to identify it's for the legislator to make choices in legislation in this respect. So that's exactly the same we say here, but we say that the reasoning again, in the Netherlands case, extends far beyond those who are intersex. The reasoning is that it is the gender experience is of decisive importance, and that is the determining factor rather than physical appearance or medical condition. I'm going to move then to the balancing exercise and the vexed question of the margin of appreciation. We say it arises in two contexts. It arises in assessing whether the fair balance has been struck between the general interest and the interest of the individual. And just the reference in Van Cook, in both contexts, the state enjoys a certain margin of appreciation. That's paragraph 71 of Van Cook.
Sorry, paragraph 71.
71. I don't intend to take you back to Van Cook at this point, but just for your note also, paragraph 72 emphasises the particular importance of matters relating to a most intimate part of an individual's life in that context. And then in implementing the positive obligation, that's where the state enjoys a wide margin of appreciation, and that's Goodwin paragraph 85, and I would, if I may, ask my lady and my lords to turn that up. Again, going back to the paragraph, tab 32 in bundle B.
Can I put the international one?
Yes, I'm so sorry, we're done with internationals until Ms. Cars-Friss is... thank you, I'm sorry, I know I'm jumping around, but... So it's B,
C.
B and C. And it's tab 32 in B. Starting at page 1320, this is part of the section of Goodwin dealing with the state of any European and international consensus. And of course, I accept entirely that what is said in Goodwin in relation to international consensus within contracting states is that there was an emerging consensus back at the time of Sheffield and Horsham, and that there was a continuing international trend for legal recognition in relation to trans persons. And effectively what the court then does at paragraph 85 is, it explains why it feels able to move away from its reasoning in Rees back in 1986. It noted that there was little common ground existed between states, some of which permitted change of gender, some of which did not. And generally speaking, the law seemed to be in a state of transition. And then in Sheffield and Horsham, Court's judgment laid emphasis on the lack of common European knowledge as to how to address the repercussions which the legal recognition of the change of sex may entail for other areas of law, such as marriage, filiation, privacy and data protection. And then this is the point, which is that appears to remain the case in terms of the repercussions, but they say the lack of a common approach is hardly surprising, because it's primarily for contracting states to desire the measures necessary to secure convention rights and to resolve within the domestic legal systems the practical problems created by the legal recognition of post-operative gender status. The contracting states must enjoy a wide margin of appreciation. So that is, once the right is identified, how you go about securing it, the method of implementation, that's where you get the wide margin of appreciation. And we don't dispute that in any way. But this is the court explaining why, actually, the concerns expressed in Sheffield and Horsham dealt with a slightly different question, not with the positive obligation that arose in the first place, but actually assuming that obligation arises, how you go about implementing it. And there, of course, they'd recognise that there was a divergence of practice between contracting members, but that wasn't the question when it comes to considering the positive obligation. But that's the point at which you have this wide discretion because of the divergence of domestic legal systems and the like. And so what the court here says, it attaches less importance to that lack of evidence on the approach to the resolution of the practical and legal problems posed than to, in this case, clear and uncontested evidence of a continuing international trend in favour not only of increased social acceptance of transsexuals, but legal recognition of the new sexual identity of post-operative transsexuals. So you've heard what I say in relation to that. We say that there is a developing international trend. It is a continuing international trend, and it is in favour of increasing social acceptance not only of non-binary individuals, including non-gendered persons such as the appellant, but increasing legal recognition of that, whether that be by way of ex-passports or more broadly, such as we see in Germany and the Netherlands. But one shouldn't read from the wideness of the margin of appreciation that's referred to there, one shouldn't read that into the primary question, which is, well, does the obligation arise in the first place? And so that's why when you read paragraph 67 of Hämäläinen, which it introduces saying concerns implementation rather than the existence of the Article 8 obligation, one has to be slightly careful. Our position is that there are effectively three levels then of margin. The first is a restricted margin.
Just it. We haven't got past time.
I apologise, I'm conscious of the time,
Yeah,
but I will
get
slow.
in this. So 3 levels of
Margin.
But just before you go on to that, you gave us a reference in
It was
Hämäläinen.
67 to Hämäläinen, again, the paragraph that I read before, which is where it sets out the general principles, the first in relation to whether the positive obligation arises, and the second is introduced as being in implementing that positive obligation, but there's some, I accept that there's some overlap between the two, but it's the implementation which gives rise to the wide margin.
Yes, we have that. Right, 3 levels of margin appreciation.
3 levels. One is the restricted level, when a particularly important facet of an individual's existence or identity is at stake. And we say that is this case. It is wider, and that's what Goodwin says, it may be wider when there is no consensus within the member states of the Council of Europe, either as to the relevant importance of the interest at stake or the best means of protecting it, particularly when the case raises sensitive moral or ethical issues. And again, that's set out in Hämäläinen. And then there's the wide margin, if the state is required to strike a balance between competing private and public interests or convention rights. Again, that's set out in Hämäläinen 67, distilled from the other authorities. And then separate to that, again, wide when it comes to implementation proper.
Is there to any European authority that makes that analysis, or is that your own?
No, that's Hämäläinen paragraph 67. I'm sorry, we've seen it so many times I didn't want to necessarily take you back, but that's what I'm referring to in Hämäläinen 67. Now, starting backwards, we say that this is not a case where there is a wide margin. And we say that because we're not dealing with implementation per se, and we're also not dealing with a situation where there are competing private and public interests or convention rights. So it's not akin to the situation in JK or TT when the interests of the child born to the adult who's undergone gender reassignment also has to be put into the balance. We say even less so is this a case where the margin of appreciation will be at its widest, which is the assertion made at paragraph 29 of the respondent's skeleton. And we note that their analysis includes something that doesn't appear in Hämäläinen or Goodwin, which is that these substantive issues give rise to difficult and controversial areas of social policy. Now, that, we say, appears to have been borrowed from the authorities that deal with particularly social security payments such as STEC in the United Kingdom. We would accept, of course, that the margin of appreciation is at its widest when it comes to those sorts of matters, general measures of economic or social strategy or social security payments, for example, as in STEC. But that isn't this case, and that analysis doesn't appear in Hämäläinen or Goodwin or those line of cases. And the real dispute between Mr. Reid and myself then comes to, as it were, the first two, the restriction and the consensus points. And we've dealt with this in our skeleton at paragraphs 14 and 17. I'm about to take, my Lord, the Court to 2 Strasbourg authorities. I'm very happy to do that.
I think that would probably be, we'll do that after lunch, I think.
It might be preferable to leave it for a moment. I'm very grateful.
Thank you very much. 2 o'clock, please.
Rise.